Right, distinguished representatives, ladies and gentlemen, welcome to the panel on overcoming barriers to effective judicial remedies. Now, we know that judicial remedies represent an important leg, and in fact, I should say, the ultimate post in the wider access to remedy strategy in the protect, respect, remedy framework. And the guiding principles recognize this fact fairly clearly, and nevertheless, the guiding principles also acknowledge that judicial mechanisms are not always perfect because of their association often with legal, practical, and procedural barriers that can prevent legitimate cases involving business-related human rights abuses from being addressed. Now, the subject we know is not new and is one that has engaged bright minds and actors over the years. And some of the issues so far highlighted include the nature of corporate structures as a barrier, the cost of litigation for victims, capacity of state authorities to respond to modern developments relating to globalization, and, I dare say, sometimes issues of corruption. Now, when the Human Rights Council established the working group, it envisaged that the subject will not only persist, but will continue to evolve. And so in paragraph 6E of the establishing resolution, the Human Rights Council asked the working group to continue to explore options and make recommendations to national, regional, and international levels for enhancing access to effective remedy available to those whose human rights are affected by corporate activities. Now, for the working group to deliver on this task, we need at least to build up a body of evidence on the nature and, in this sense, the breadth and the depth of analysis of these barriers, and to assess the ways and strategies of responding to them. Well, we have the benefit of a very distinguished panel who collectively, I like to think, have the body of wisdom to help us address this subject. 3 main panelists and 2 commentators. And I'd like to introduce them now and then hand over the floor to them. To my left, we have Mr. Simon Minks, who is a senior prosecutor in the Court of Appeal in The Hague and has been prosecuting a number of high-profile cases. And I'll let him sort of draw his, your attention to some of the cases that he has dealt with, including some very well-known cases. And next to him, of course, is our good old friend, Brent Wilton from the IOE. And Brent, of course, will represent the business voice on this panel. And to my right, of course, is Richard Meeran from Leigh, Co., where he's a partner. And Richard has made a lifelong career of litigation in human rights and business cases. And he, too, has led some very, very high-profile cases. And then for our commentators, we have Elida, Cristina, Tz'ununija, an indigenous community in Guatemala. And then to the far left is Seema, Joshi from Amnesty International, who needs not too much introduction for the work that Amnesty has done. The idea of this panel really is to try and get to grips with the nature of the problem, with at least some illustrations. And I mean, any specific references to cases are not meant to be case studies, they're meant to be illustrative only. But by all means, we'll have a chance to hear from the panelists, and then the commentators, and then we'll open the floor to the public. All right, without much ado, I'd like to hand over the floor to Mr. Minks. And I should say at this point, and I'd like to say it again at the end, that Mr. Minks has very kindly agreed to join this panel at very, very short notice. And we are really grateful for his offer and intervention. Thank you very much. You have the floor.
Well, Mr. Chairman, thank you very much. Ladies and gentlemen, Your Excellencies, I'm going to tell you something about the so-called Dutch approach of a special case I handled with the Proba Koala. I think it's a privilege to be here and have the opportunity to share my experience as one of the Dutch prosecutors in a very complicated criminal case with you. You will understand that a complicated case cannot be told in approximately 10 or 11 minutes, so I will give you a summary of the case and will elaborate a little bit more on the legal issue and the legislation. Now something about the case. On board of the ship, the Probakoala, a caustic washing process of coke or gasoline, forgive the words please, had been carried out. And as a byproduct of that process, there was a lot of hazardous waste material. And the question for the owner, in this case Trafigura, who also chartered the ship, was where to process the waste. The waste was refused by some companies around the world and finally offered to a company in Amsterdam in the Netherlands and described as so-called Marple Annex 1 waste. In other words, normal waste from a ship, which was, of course, not the case. On the evening of the 2nd of July 2006, the company in Amsterdam unloaded some of the waste, but the receiving captain, Dutch captain, didn't trust it because of the strange and the typical strong smell of it. People start calling with health complaints like headaches. Soon after that, the company and the Dutch police took some samples and the first test indicated that the waste had a significantly higher chemical oxygen demand than expected. So the company raised the price for processing the waste because it required a more specialized treatment than they could provide. And they wanted to send it to another more specialized company as well. But Trafigura refused. They refused to pay the higher price and asked the company to pump the waste back to the Probakoala. The police and the prosecution office warned not to do that, but the company thought they had a right to pump it back, and so they did. The Probakoala left very quickly the harbor of Amsterdam, and finally, you probably know, the Probakoala delivered the waste in Abidjan in Ivory Coast. Now, what were the charges? The Dutch prosecution started the prosecution against Trafigura, but not only Trafigura, also his CEO, an involved employee, the captain of the ship, the company in Amsterdam, and also the city of Amsterdam. Because of my limited time today, I will just focus on the charges against Trafigura. 3 charges are there. First, exporting waste from an EU country to an ACP state in violation of Section 18 of the European Waste Shipment Regulation. 2, delivering goods with, to their knowledge, presented as hazard to life or health and concealing the hazardous nature of the goods. And 3, forgery. After years of legal criminal proceedings, Trafigura was in the district court and also in the Court of Appeal acquitted of involvement in the forgery. In fact, there was just one single statement of the captain of the Probakoala who couldn't be found in the appeal stage, so we couldn't hear him as a witness. But Trafigura was found guilty of exporting waste on board the Probakoala to an ACP state and that the export of the waste had been done with malicious intent. And on the second charge, having delivered goods to the Amsterdam company which to their knowledge presented a hazard to life or health, and of having concealed the hazardous nature of the goods. Finally, Trafigura was fined with €1 million for the breaches under these 2 charges. But you might wonder and might ask the question, what about the dumping of the waste in Abidjan? Greenpeace Netherlands asked the Dutch prosecution to start another criminal investigation against Trafigura and others, namely for the possible criminal offences related to the dumping in Ivory Coast. My colleague refused that because it appeared at that time impossible to conduct a proper investigation in Ivory Coast. And because of the refusal, Greenpeace asked the Court of Appeal in The Hague in 2009 to overrule the prosecution. And on the 13th of April 2011, the Court of Appeal in The Hague dismissed the complaint. And I quote, "The Court of Appeal has disallowed the demand of non-profit organization Greenpeace in the Netherlands requesting the prosecution of Trafigura and others for manslaughter, cross-maltreatment, involuntary manslaughter, involuntary grievous bodily harm, or criminal offences committed in the course of one's duties or profession." As a matter of fact, Greenpeace, contrary to the victims and dependents, is not a direct party concerned in the requested prosecution. That's what the court said. Nonetheless, this requirement is prescribed by law. With respect to the non-prosecution pursuant to Article 173 of the Dutch Criminal Code for the dumping of illegal waste in Ivory Coast in August 2006, the Court of Appeal has dismissed the complaint because the feasibility of prosecution in the Netherlands is doubtful. Offences committed in Ivory Coast cannot be brought to trial in the Netherlands by definition. None of the suspects has the Dutch nationality or lives in the Netherlands. And for the main part, the professional activities of the accused companies took place outside of the Netherlands. The Court of Appeal is also of the opinion that if prosecution would be ordered, further criminal investigation should not be omitted. However, until this moment, the judicial authorities of Ivory Coast, and you must think about 2011 at the time, have not rendered their cooperation to the execution of Dutch request for legal assistance. And therefore, the Court of Appeal considers that the prosecution has made enough efforts. The prosecution has carried out a thorough investigation in this case and is prosecuting a number of suspects, including the accused Trafigura in the Netherlands for the illegal export of waste from the Netherlands. Moreover, in Ivory Coast, 2 suspects have already been convicted for their involvement in the actual dumping of the waste, and 2 of the suspects have already been in pre-trial detention. This detention was ended after a financial settlement had been agreed upon Trafigura and the state of Ivory Coast for the compensation of damages to the environment, among other matters. Finally, in civil proceedings, settlements have been made with dependents and victims. I just spoke about 2 cases against Trafigura, but you can also read another company as well. But as a matter of fact, in this particular case, there were some other potential cases as well, which finally, after negotiations, were settled out of the court. Now, what should states do to address barriers with this kind of cases? One of the key guiding questions of this panel is what states should do to address these barriers. The lessons my colleagues and I learned from this particular case against a powerful company is that, first of all, there must be the intention, the real intention to prosecute if there are serious reasons to think that violations of human rights are at stake. But at the same time, you must not raise false expectations. Look seriously to the jurisdiction rules in combination with a fair trial. Don't forget that. A fair trial is what's important. We learned from other cases as well that it is very difficult to find and to collect evidence, to speak with witnesses abroad, and so on. And don't forget that the accused also has rights to check the evidence, to ask the witness questions, and so on. Last but not least, give the prosecution, also in a country like the Netherlands, enough time and enough money to prosecute. Because that's not so certain in every case. We are also limited in time, and we are also limited with our money possibilities. If I look at these complicated cases, then my advice is to check your own legislation and look whether there is a balance in rights between the prosecutor on one hand and the accused on the other one. And find a way to establish the rights of the victims, don't forget it. So their voice can be heard and, like in the Netherlands, can be asked for compensation. In other words, check your own legislation, try to implement the Rocky principles as much as you can, don't raise false expectations, but keep in mind that it is worthwhile to prosecute powerful companies, especially when human rights are at stake. Thank you very much.
Thank you very much, Mr. Minks. And we have particularly noted the idea, the suggestion of sticking close to the Rocky principles. That's very sweet to our ears. And also the idea of seeking the voice of victims. I think that's very, very useful. I'd like to give the floor now to Richard Meeran from Leigh & Co.
I'm going to focus on barriers to effective remedies in claims against multinationals in the multinational home courts. So, in other words, mainly claims against multinational parent companies. I think this is a sensible approach because, in reality, in general, it's almost impossible in practice for people to pursue claims against multinationals in developing country courts. In the European Union, we have the Brussels I regulation, which gives the EU courts mandatory jurisdiction over companies which are domiciled in those countries. So if we're dealing with a claim against a multinational parent which is domiciled in the UK, then the courts have mandatory jurisdiction and the claim cannot be displaced on the grounds of forum non-conveniens, on the grounds that there's a more appropriate forum elsewhere. That wasn't the case prior to 2005, and the experience before then was that cases were invariably held up for years, arguing over forum non-conveniens. That is still an issue, obviously, in other countries, the US, Australia, Canada, where forum non-conveniens is still very much alive and kicking, and in the US probably very important now in light of the Kiobel decision of the Supreme Court. In claims against multinational parent companies, the issue of the corporate veil always raises its head. This is the principle, as you know, which protects a shareholder from the wrongdoing of companies in which it invests. And multinationals have invariably argued in cases that they're not liable because they're a shareholder and they can't be liable for the wrongdoing of shareholders. What we have tried to do in all our cases over the last 20 years is to focus on the wrongdoing of the multinational parent company and to try and link that to the harm that has occurred on the ground. So we're looking at the direct negligence of the parent company and the manner in which its acts and omissions can be linked to any harm that occurred on the ground. So these are cases in the UK at least which have been run as negligence cases, not as human rights cases. They do not allege human rights violations, although the subject matter very much is human rights. And examples of cases of that type are the cases against Cape plc for South African asbestos miners, against Thor Chemicals for mercury poisoning victims, and most recently against Anglo American for gold miners with silicosis. And that notion of a parent company duty has been increasingly recognised by the UK courts at least. Now, in order to establish the linkage between the conduct of the parent company and what happens on the ground in a developing country, it's necessary to understand the relationship between the various corporate entities within a group. And usually that kind of information is uniquely in the hands of the company. So therefore, effective discovery disclosure procedures are required in order to enable claimants to obtain access to that kind of information. In the US, there are very effective discovery procedures. In the UK, we also have quite good discovery procedures, but I believe that the ability to access documents is more limited in other states, for instance in the Netherlands, and I believe there has been a case recently where that has caused serious difficulties for claimants. Under the Rome II regulation, the applicable law in these cases is invariably the local law, and that includes the law that determines the amount of damages that are payable to victims. Now, that may seem justifiable from the point of view of the cost of living issue, but it sends out a bad signal with regard to deterrence, and it means that a person in a poor country where damages are low is going to receive less damages, and therefore the deterrent against bad practices is going to be lower. So, for example, a Swazi miner who has an asbestos-related disease is likely to receive less than a US victim, a US fear of cancer victim. Someone who walked past an asbestos factory and was worried that he might contract asbestosis is likely to receive more if he's in the US than a Swazi asbestosis victim. I'd just like to end with the really important issue of access to lawyers and funding, which is obviously critical to access to justice. We're dealing in these cases with claimants who cannot afford to pay, and certainly in the UK there is no longer any public funding or legal aid for this type of case. This means that claimants' lawyers have to fund cases themselves right through to the end. Now, we're dealing here with cases that are novel, very complex and resource intensive. And on the other side we have defendants who are usually represented by an army of in-house and commercial lawyers who fight tooth and nail to avoid being held liable. Now, these are factors which make cases very risky for claimants' lawyers, both in terms of the merits and the potential cash flow implications, because they've got to carry a case for an uncertain period of time, not knowing whether it's going to be successful at the end, and having to bear often very considerable expenses. Now, the only lawyers generally who are in a position to take on that kind of risk are large commercial firms. But large commercial firms are usually conflicted out because they act for companies. So this is a serious problem for claimants. In the UK, there have been financial incentives for lawyers to take on cases, and this is in the form of no-win, no-fee agreements under which lawyers get paid success fees if the case is successful. So they have the potential, or they have the potential to receive a higher fee if the case succeeds, and obviously not get paid if the case fails. This year, the UK government introduced legislation, costs legislation, which effectively removed that potential incentive for lawyers by removing the requirement that the defendant pays the success fee. This means that the success fee now has to be taken from the claimant's damages, and the result of this is that in all but the biggest cases, which attract the largest amount of damages, the financial viability of cases has been significantly reduced, and the incentive on claimants' lawyers to take them on in the UK has been significantly reduced. For small cases, opt-out class actions are an important mechanism which have the effect of reducing costs by enabling representative claimants to sue for a wider class. The opt-out class procedures are available in the US, Canada and Australia, and also in South Africa now, but not yet in the UK, where we have group actions but not opt-out class actions. So in summary, I would say over the last 20 years, significant headway has been made in terms of the obstacles to achieving an effective remedy, but there is still a very long way to go.
Right, thank you very much, Richard, for that breadth of assessment. I think we should go now to Brent. We hear the business view.
Thank you, Chair, and good afternoon, everybody. Following on after two very distinguished lawyers is not an easy task to do, I can tell you. My organisation represents employer organisations in 150 countries around the world. So my members are made up of national companies as well as multinational companies. And I want to talk more holistically around some of the issues that are raised by the debate in this panel. and to look at the ways in which we might be able to start to overcome what is seen as the barriers to justice. And some of those examples have been raised here, but I think it's also important to put this in a context of this is a business debate. It's not just a multinational enterprise debate, and I think that's very important. Where there are barriers to justice, where there is a failure of the rule of law, it affects everybody in every instance, not just in a human rights context, and I think that's important. Where the rule of law does not exist, be it for criminal cases, commercial cases, property cases, family law cases, etc., everybody is suffering. My members in many countries suffer with legal systems which are not efficient and effective in providing remedy in a timely manner. So I think we need to understand that a failure of the rule of law impacts across a community very, very widely, not just in a single silo of human rights. And it's very important for us also to remember that under the Ruggie principles, in terms of the duties of the state has the duty to provide the rule of law. Nobody else can do that. Business is certainly not equipped to do it, nor are the citizens of a country. The government has to act and put in place that rule of law. And where that rule of law exists, you get what's known as a compliance culture. And you see it in countries where you don't go out and kill people because you know if you do, you'll be caught, prosecuted and sent to jail. So people learn a compliance not to do certain things through the application of the rule of law. So again, in a human rights context, if you have the rule of law, people are more attuned to the issues of human rights and more mindful of the way in which they behave. And don't forget also, when you're looking at countries where there is a failure of the rule of law, that business is the community at work. If the community does not respect human rights, you cannot expect those people when they go to work to suddenly put on a new hat and be human rights achievers. They won't. They will reflect the nature of the community they come from. So this is why the rule of law as a concept is so very, very important for all of this. Where you have the rule of law, when it comes to the responsibility of companies, it becomes a lot easier because it's easier to inculcate that within a company where the staff themselves are compliant in terms of the way in which they approach the law in their own lives. And that is very important. It's also important, I think, when we look at some of the issues that have been raised by other speakers, that when we're looking at a human rights issue, what we should be focusing on, in my view, is the restoration of that person's entitlement to the right. And that seems a bit to me to be lost in the compensation debate. It's not so much about restoring that person's enjoyment of the right, but to get some money. And I think that is something we have to be very careful about. Yes, there will be occasions where harm is done and compensation is an entitlement that should be considered, but not in every instance, which is why, again, it is important to make sure that the government, in looking at its obligation, is looking at putting in place low-level, speedy and efficient systems. Last year when I was here, we talked about the role that human rights commissions play at the national level in putting in place these mechanisms that enable people to get their remedy sought very quickly, as close to the problem as possible, as fast after the event as possible, thereby mitigating damage and enabling that right to be restored more readily. If the right is ignored and dealt with over years of litigation, then that's a problem. So we need to focus again on how do we help the state. It's also important to make sure that liability rests where it belongs. And again, under the Ruggie principles, the duty to respect in the instance of business applies to every business wherever it is. It doesn't just apply to the home country of a multinational. Everybody, under the Ruggie principles, should be applying its responsibilities appropriately. So again, this is, for me, a very simple case, again, of the need to make sure that the remedies that we are looking to put in place to help governments address this issue of the rule of law is done at the lowest level possible. And there have been good examples of that. I mentioned the Human Rights Commission approach on mediation or adjudication, alternative dispute resolution mechanisms which are being explored increasingly in a number of jurisdictions, not just in terms of human rights, but in a range of issues across criminal law in order to expedite what are seen as blockages in the court system. There is more government should be doing by way of donor support for countries that do have rule of law problems. Again, over many years I have watched a variety of different initiatives be undertaken by governments, by NGOs, by UN agencies with regards to trying to assist in the development of the rule of law. But these are largely incoherent and very inconsistent. And I think one of the things we can do to help governments is to bring to some of that coherence to the table so that governments are able to address these issues with donor support in a proper way. I deal a lot with the International Labour Organization, and there is a big program which is undertaken to train judges in labour law. That's part of this equation because of the 4 principles arising from the 1998 Declaration. That's an aspect of what we should be doing here. So I think it is very important that before we give up on the rule of law, before we just say, let's look for other avenues of redress, let's look at the answer of extraterritoriality, think about what the impact of that failure of the rule of law means to a community and to a society, and that the realization of rights are more likely to be achieved if we take an integrated approach to addressing that issue within that community or society across the range of issues where legal remedy and access to justice is required. Thank you.
Thank you very much, Brent. Well, that essentially concludes the main panel presentations. I'd like now to go to our commentators for their reflections on the presentations. I'd like to go to Elida, Cristina, Tz'ununija from Guatemala.
Gracias.
Thank you. We've heard something about the experience in the Netherlands and in the United Kingdoms. However, the context in which Indigenous people live their lives is very different. And we have heard something about the barriers that exist. The fact that we need economic resources to try and really go into all of the cases of violation of the rights of Indigenous peoples. We've also heard about those cases when Indigenous peoples actually file complaints, and the majority of cases, these are disregarded. Guatemala is a country that has ratified a number of instruments to protect human rights. And yet, despite this, when the justice system actually has to apply this, there are all sorts of problems. And we have to look to the structural history of the country as well. First of all, the legal framework of Guatemala is an excluding one, and it is racist. It doesn't recognize Indigenous peoples as rights bearers. Secondly, people who work in the justice system use certain criteria in implementing treaties. So we see that the state is not always bound to its obligations as a result. The justice system also goes along with national and international commercial policies. And they very much limit the practical implementation of these instruments. When Indigenous peoples demand the respect of their rights, they have often been criminalized. They've been accused of terrorism, of trying to destabilize the legal system, and of perpetrating an attack on democracy. And all of these acts remain unpunished. We have the very special case of the Indigenous women of the San Miguel Ixtamacan community. They were persecuted by the Martin company, a subsidiary of the Canadian company. The women were simply defending their land rights because the company occupied their land, because they were trying to pass high-tension electric cables through the territory. The women were against this. The company filed a complaint saying that they were illegally occupying the land. But in fact, there was no case to answer here because it was the company itself that was occupying the land and not the women. So the decision was overturned, and it ended up being the women who were held responsible. There are very many similar situations that affect women and men who are leaders of their Indigenous communities. There is a veritable persecution at the hands of the corporate sector, and this is with the collusion of the state. Now, there was a particular legal strategy used in certain cases. We needed resources to try and prove certain facts relating to the women's conduct. We allied ourselves with the women's movement as a strategy, and to try and make sure that we could bring our case. We also tried to seek support from the international level with the Amnesty International, for example, and other international human rights defenders. And we also turned to the Office of the High Commissioner for Human Rights in Guatemala. So the case was finally settled because all of these human rights defenders helped us. The 8 women were finally released from the charges, and the land on which the rights had been violated was returned. One of the recommendations that we wish to make to the state is that they guarantee the rights of Indigenous peoples and that they don't criminalize such communities in order to protect corporate interests. We also believe Indigenous territories ought to be demilitarized. This has also been a state policy. They have sought to militarize territory to try and impose corporate interests. Turning to companies, we would ask them not to be meddlesome in the courts of justice. And we would recommend to the working group that they draft a report on cases where the defenders of the human rights of Indigenous peoples have been criminalized. We also believe that these violations ought to be brought to light. We would turn to Indigenous communities and tell them to use the human rights instruments to make sure that the violations of their rights are made public.
Thank you very much, Cristina, Elida, and for your intervention. I'd like to turn now to Seema Joshi at Amnesty International for her reflections on the presentation.
Thank you very much. Thank you for the opportunity to speak today and to also reflect on some very interesting presentations from the panel. I was particularly interested and also very happy to hear Mr. Minks speak about the Trafficura case, as I was also hoping to mention the Trafficura case. So I'm very happy that he gave such an excellent presentation. You know, I believe on from a prosecutor's perspective, exactly the types of so what you need legally as well as practically in order to make these types of prosecutions happen. In 2012, Amnesty produced a report called The Toxic Truth along with Greenpeace, where we documented the dumping of the toxic waste in Abidjan, as well as the human rights impacts that led to, which led to largely to immediate health impacts as well as within the long-term unknown health impacts, and that's largely because there is no monitoring happening in Ivory Coast right now to actually see, you know, if there are any long-term consequences from the dumping of the waste. In addition to the waste being dumped, our understanding when we produced the report last year is that the sites have not been fully decontaminated as of yet. So that actually means that there are people feasibly living in around these dump site areas where the waste continues to sit there, and it's actually unknown and there's no monitoring as to whether or not there's any ongoing health impacts as a result of that waste not being cleaned up. I think the Trafficura case is so interesting on so many levels because it's we talked about the Dutch personality part of it, but actually it's a company with multiple nationalities. The research that we have done has indicated that the Trafficura Limited, which was registered in the United Kingdom, actually directed the operations that led to the waste being dumped in Abidjan. We also know that in France, there were attempts to bring prosecutions in France against Trafficura. We know, as was referenced, that in the Ivory Coast itself, the prosecutor there did initially bring charges, but as was mentioned, these charges were subsequently dropped once a settlement agreement was entered into between the government and the company. From an access to justice perspective more broadly, not just from a judicial perspective, that's a severe problem. When you have state authorities and prosecutions being terminated because of a politically agreed settlement agreement, they're different, and politics actually should come into law and legal enforcement. As a result of the settlement agreement, one of the provisions was that the government or the agreement was made not to undertake future prosecutions against the company in the Ivory Coast. That's a problem because it even infers that should there ever be new evidence that comes to light against any members of the Trafficura group, in fact, because of the settlement agreement, the prosecutor can't take it up. That's immunity that's been provided to the company because of a settlement agreement. I just wanted to raise that because when we look at prosecutions and court action, there's often another context that's working alongside. And I think that when we are considering removing obstacles, we need to consider that context as well as how they affect the court process. I think that the last thing I want to say on the Trafficura case is that it is true that to this day, so the waste was dumped in 2006. To this day, there's actually been no prosecution and or any sort of legal investigation or legal remedy provided into the actual effects, the human rights consequences of the toxic waste exposure and the dumping. One thing that Amnesty International is interested and is exploring is that, we believe that, for example, the UK state authorities, that there may be grounds to actually consider looking into conduct, decision-making processes that were undertaken by the company in that instance. So moving away from Trafficura, in reference to Richard Meeran's presentation, we largely agree with a lot of what Richard said, which is probably no surprise. And I think that, in the research that we've done, as well as the research being done by a number of other NGOs, there's so many here that are working on obstacles to judicial remedy that it's hard to mention them all. We have a report that's actually being produced by a coalition called ICAR with ECCJ and CORE on access to remedy. As well, Amnesty International is producing a report in January with recommendations on removing obstacles to judicial remedy. Within these, both reports actually have referred to this idea of creating a presumption of liability on the parent company for human rights abuses committed by subsidiaries and or other members of the corporate group. I think this is an interesting concept, and building from the case law, some of it that's happened in the UK, we believe that this is an area that needs to be further explored in terms of creating legal change. In terms of when we consider legal change, I think it's also important to draw from other areas where corporate liability has become more clear within the last couple of years. So one such area is, I was speaking to a very good American lawyer earlier about U.S. trafficking laws and how, at the state level now corporate liability has been clearly defined and the requirements identified as to when corporate actors can be liable, when a sort of associated entity or an agent has engaged in trafficking, on their behalf. I think, we can learn from some of these standards of care or criteria that have been laid out. In other areas, product liability, there seems to be a strict liability that falls in companies in this area. It'd be interesting to see how this can apply to other human rights. The last area we can draw from as well is corruption. The UK Bribery Act is quite interesting because there's a provision that refers to the failure to prevent corruption. So if an accessory carries out corruption, there's a strict liability that falls on the parent company. So it's all quite interesting because there seem to be quite expansive provisions within some areas of law, and I think we need to look at how these developments can actually be applied within a human rights context. I know my time is running short, so I just wanted to quickly talk about, I guess, in relation to the rule of law point that was brought up. I think today it's a really important day because it's also the 29th anniversary of the toxic gas leak in Bhopal, which happened in 1984. For people who don't know, Bhopal is a place in India, and the Union Carbide factory that was being operated there, essentially there was a toxic gas leak, which people essentially suffered from during their sleep late in the hours of December 2nd, and also continued to feel the immediate effects of on December 3rd. Within a couple of days, at least 15 to 17,000 people died. Even until today, evidence suggests that 100,000 people continue to be affected by the toxic gas leak, as well as the ongoing consequences from Bhopal. The most shocking part about Bhopal is that actually it's the emblematic business and human rights failure, because everything that should have happened actually has not happened. We spoke a lot about the cases. There have been a number of cases that have been attempted in the United States. I believe that one case is still in existence. I think the other cases have all been dismissed for a variety of reasons. The U.S. jurisdiction is because of Union Carbide, and also because of its, because of Union Carbide, it was a U.S.-based corporation. Subsequently, in 2001, the company Dow purchased Union Carbide, and since then has come into the fold in terms of corporate responsibility to the people in Bhopal. What's more interesting is that within India itself, there have been a number of court actions that have been undertaken. There's criminal court actions in which Union Carbide, criminal charges were brought against Union Carbide for culpable homicide not amounting to murder. Union Carbide, those charges were brought almost 20 years ago. As a result, Union Carbide actually absconded from justice and has actually never appeared before the Indian Criminal Court to respond to the charges that were brought against it. Despite the fact that Union Carbide has never appeared, Dow, which 100% owns Union Carbide, has never made Union Carbide appear before this court process. And more recently, the Indian court has actually called on Dow to appear before the Indian court and to explain why it's never made UCC, its 100% owned subsidiary, appear before the Indian court. India is an interesting example because it does have a rule of law, and it does have a very sophisticated legal system. But even in this instance, we have a company that's basically absconded from justice. And what we need is more action to ensure that in situations like this isn't allowed to happen. In terms of other litigation that's ongoing, I think what we can also learn is that there's a litany of litigation in India, and what we need to see is results in terms of remediation and environmental cleanup. So the more we can do in terms of recommendations to support victims and bringing sort of litigation and mainstreaming them in an effective way would be useful. Thank you.
Thank you very much, Seema. I think we've reached a point where we throw the floor open to you. We'll follow exactly the same format as we've done since the morning. Designated microphones for states, for businesses, and for civil society. And if you wish to speak, I suggest you take one of those empty seats and then speak for no longer than 2 minutes.
Muy buenas tardes a todos.
A very good afternoon to you all. Javier Sapea is my name, and I'm a representative from Guatemala, from the Chamber of Commerce, actually. Thank you very much for giving us this opportunity. We've heard quite a lot about Guatemala in recent minutes and in the forum overall. We do respect the rule of law as entrepreneurs, and we support the views expressed by the panelists. So we support the rule of law, but we also don't think that these fora ought to be hijacked as an opportunity to focus unduly on what is happening in one country. both in corporate or in social terms. I think it's important to strengthen the rule of law and to ensure that it's respected. And if a company breaks the law, then things must be done to ensure that it complies with them. However, we cannot have statements that are groundless and people taking the floor simply to discredit a country. I think statements must have a basis. James Anaya came to Guatemala, and he was told that there were companies that were established that were polluting the environment. But that was entirely false because the company hadn't been able to put a plant in operation. So I think we have to know what the true situation is in Guatemala. And if we do that, then we will build a world that is much more harmonious. Thank you.
Thank you very much, the representative of the Chamber of Commerce from Guatemala. Now, before I hand over the microphone to the civil society, I should say, on behalf of the working group and perhaps the Human Rights Council, no specific effort or decision has been made to target a particular country. I made a comment right at the start that any particular reference to cases or countries is done in an illustrative manner. So I like to affirm that nobody is targeting Guatemala. Secondly, I'd like to say that this is meant to be an open dialogue. So I take your point that, if there are inaccuracies, we ought to find ways of remedying them. And I really will welcome your own thoughts on trying to get to your contribution to get to the correct facts. So perhaps at another time we will expect some further contribution to join that dialogue. Okay, thank you. I'll hand over the microphone to the civil society.
Muchas gracias.
Thank you very much. Juana Coite is my name, from Conecta, human rights organization in Brazil. I wanted to thank the speakers for the presentation of cases in the field. I think all of this shows that we need much more than simply disseminating information. Very many have pointed out that one of the main limitations of the guiding principles is in the barriers stand in the way of effective judicial remedy. So we've heard a lot about the problem and very little about the solutions. So may I ask the question, what are the specific plans that the working group has for pressing ahead with this issue? It's the second time that during the forum we have a panel on the barriers to effective judicial remedy, but we still have heard nothing about what proposals have been made to actually overcome the barriers. Thank you.
Okay, thank you. I'd like to go back to the microphone for the states. If any state party wishes to take the microphone, it's free.
I just wanted to make a short comment on behalf of the UK. Firstly, to welcome this rich discussion on remedy and also the important work of the UN Working Group in this area and steering the debate forward, which I think will be important in the months to come. I just wanted to reflect the fact that the speakers have set out, really the kind of the different elements of the right to remedy, and we have heard in the different presentations, the full spectrum from civil remedy, including civil remedy available through UK courts, the criminal prosecution angle and the challenges in interstate cooperation, grievance mechanisms at a company level or mechanisms that companies can participate in, and alternative adjudication. From a UK perspective, all of these elements of remedy are important, and we've highlighted that in our UK National Action Plan. I'd also like to highlight that in our UK National Action Plan, we've committed to supporting access to remedy, including access to judicial remedy in projects and work around the world. And we stand ready to help other states in improving access to judicial remedy. We've also committed in our National Action Plan to keep the UK provision of remedy under review, and feedback from sessions like these are important. Thank you.
The rules of procedure suggest that I go around the various stakeholders. So I now move on to the microphone for the business table.
Thank you, Mr. Chairman. My name is Bert Fokkema. I work for Shell. I would like to say something about the oil and gas industry. I hear there are complicating factors in access to justice, and the panel members focus on home country and extraterritorial solutions. I would like to share with this meeting here that there are alternatives, And I would like to please you to consider the following. Business is not interested in long and complicated court cases. Their business is in the process of implementing United Nations guiding principles, but it does take time. Oil companies are finding it increasingly, or not just increasingly, as a routine that their impacts are mostly very operational. They're about noise, dust, trucks, and we deal with those operational impacts on the ground at locations very quick and very effectively. We want to avoid those things escalating into long-term or complex court cases. We are in the business of preventing things from happening. I'm sure there's also a room and a need for judicial systems and maybe extraterritorial systems, but let's look also at the pros and cons. On the con side, we've already heard from the panel, they're expensive, they take long. Importantly, they're not accessible to all. They may create conflict by the time some of those people come back in their villages. Some have a compensation, others not. And very importantly, they are always adversarial. They may not help in reconciling conflict or differences at a local level. So only local solutions can provide redress across society. And I would seek leverage at this meeting here from governments who are looking for things to do with their money to spend it on building capacity for local courts in those countries where they are weak. I would call on companies to look at their operational level grievance mechanisms, to pick up complaints early, to avoid escalation. And in that respect, I would like to mention a project by APICA, the Oil and Gas Industry Association, where their members are coming together to share experiences around grievance mechanisms in the field in many different locations. Building on the publication of last year, we'll publish more practical guidance for oil and gas about the pros and cons and what works and what doesn't work around operational level grievance mechanisms. So avoidance is better than having an issue, and local level solutions are, in our mind, much more efficient and effective in dealing with complaints and issues. Thank you.
Thank you very much. I think there will be another round of speeches, so I want to go to the civil society group, and then I will come round again. I know there is a little bit of misunderstanding on that table. Okay, civil society.
Thanks, Chair. My name is Surya Dev. I teach at the Law School of City University of Hong Kong. I have two observations to make. My first observation is with reference to the presentation of Mr. Wilton, and I have two interconnected comments about it. The first is I fully agree with you that rule of law is an issue. But I think we cannot justify lack of rule of law, and that should be the basis of companies violating human rights and claiming, oh, there was no rule of law there, and that's why let victims suffer. Because we need to make a distinction between a situation where companies voluntarily entering a society or jurisdiction where rule of law is not there. But the people living in that society do not have this voluntary option. They are involuntarily suffering from violations of human rights, so we cannot equate the situation. The second point, it is, in my view, very unethical for companies to plead separate personality when it comes to violations and refer to the Ruggie principles. But when it comes to claiming that we are such a large company, large group, we are operating in 80 countries, we have so much profit, then this separateness disappears. The group claims that all of us are part of this group, and that's why this paradoxical situation is unsustainable and as well as unethical. My second observation is sort of a comment or query to the working group, that whether the working group has any plans to look at making some concrete recommendations to improve the access to justice when it comes to judicial remedies. And I think this is critical, not merely to enhance the robustness of judicial remedies. This is also crucial to complement non-judicial systems that are going to work, because non-judicial systems work better if we have a strong, robust judicial system in place. So I think that importance has to be understood. It is not other way around. So I think we should focus judicial mechanism simply because of, not for itself, but also because of the effectiveness of the non-judicial system. Thank you.
Thank you. I'd like to go back to the state's microphone, please.
Gracias.
Thank you. Thank you for giving me the opportunity to speak. I wasn't going to speak, but it's really becoming very interesting. I just very quickly wanted to give you an example, and I wanted to thank others for bringing up examples. But in fact, this is an example that is actually happening now, and it's about the abuse of corporate authority and the action of a state, in this respect, Venezuela, when it comes to defending the rights of its people. Venezuela, in exercising its actions and in defending the rights of its people, in November, announced a number of measures to fight price speculation, to regulate imports and exports, and to make sure that there's some control of currency prices. This means that some people are able to purchase currency at preferential prices and import. Some people are importing using this system and then selling on to the people at 10 times the price. The government wants to tackle this economic war and to make sure that people who have benefited in this way against the law are sanctioned. Now, we don't want to mention any names here, but this has also been done in conjunction and with the collusion of some international partners and running counter to some public policy. So systems have been used against the Venezuelan people and with the aim of destabilizing a legitimately elected government. So this economic war is being used as a tool. Now, this is an example which speaks volumes about how necessary it is to fight against abusive practices and to establish legislation to protect citizens against this abuse. The Attorney General in the Republic can put in place a whole series of measures. There are at the moment 40 traders that have been prosecuted for these practices.
You have 2 minutes and you've spoken for nearly 4. Thank you very much. Thank you.
Well, I hope my idea came across clearly anyway.
It came out very clear. Thank you. All right, we'll go to the business microphone, please.
Gracias.
Thank you. There are 3 principles that I wanted to emphasize, having listened to the presentations from speakers and moderator, that I believe are very important. First of all, the question of an open dialogue. Secondly, to abiding by the rule of law, where we're all equal before the law and making sure the law is respected in all of our countries. And my third point, what was mentioned by one representative, and that is to ensure that all the organizations that are part of the United Nations system and all of the member states of the United Nations need to be consistent in the programs and actions that are implemented and promoted in the various countries. So these are 3 important principles in my view. And in respect of Guatemala, I think it's important that rapporteurs like Ms. Shelton and representatives from the United Nations like Mr. Brunori must maintain an open dialogue, visit the country, take part in country activities, but not just focusing on activist organizations and human rights defender organizations. To make sure that there is an open dialogue, then they really must physically go and check what is happening in the corporate sector in Guatemala. I think it's important to point this out because we have seen visits from rapporteurs, but they only listen to the one part of society that is lodging complaints. They do not take part in or have any kind of dialogue with representatives from corporations. They don't even go and visit the companies that are mentioned in all of these cases in relation to human rights violations. And then there's another important issue, which is the question of strengthening of the rule of law. Less than 2 weeks ago, Indigenous communities filed amparo appeals in respect of a sentence that was handed down for the charge of raping a 9-year-old child. We think it's important to remember.
Por supuesto.
The last point I wanted to mention was the question of consistency. Now, there are, for example, smallholder agriculture projects such as the ones promoted by FAO, and they're important for us.
Please, we should stick with a 2-minute deadline, otherwise others don't get a chance to intervene. Thank you very much. I'll go to the civil society, please.
Douglas Castle from the University of Notre Dame. I'd like to comment on the presentation by the gentleman from the International Organization of Employers. I think most of us would agree with you that building up the rule of law in host countries where that is an issue is a far better alternative in theory than having lawsuits far away in the home country. But as someone who has worked on rule of law reform in a number of underdeveloped countries for a quarter of a century, I can tell you there's a problem of timing. You don't go from a country which has a tradition of no rule of law, lack of independence of the judiciary, systematic corruption, to a rule of law state overnight or even over a year. It usually takes decades. And the victims can't wait that long. So while we're building up the rule of law in the host countries, we need another way to find justice for the victims who need it, not now, but yesterday, and in some cases, as we've heard, 29 years ago. That's why it's important to have the option of home country litigation in countries that have built up rule of law while we're waiting to build it up in those countries that still need it. Thank you.
Thank you very much. I am looking at the clock, and we have 10 minutes of our session left, so I'm going to offer a chance to the panelists to comment or reflect on some of their interventions. And I know there are people still itching to contribute. We welcome any comments in writing, email, or catch members of the working group at any point, and we'll register your contribution. All right, I'd like to start with you, Seema, if you want to comment on any of the contributions.
The only thing I wanted to comment on was the suggestion that was made to focus on concrete, where we go next. One of the issues that we believe is also worth considering is our jurisdictional barriers that come into play when cases are being brought by foreign claimants. These include forum non-convenience questions and establishing necessity. These barriers still exist in countries like Canada and the United States. It would be great to see these particular issues being taken up by the working group. Thank you.
Just very quickly, I think it's important to recognise that, as was mentioned by the representative from Shell a little earlier, that this debate is not about impunity. We're not looking to escape justice where justice is owed. So I think that's an important point to make. With regards to the issue of timing, you're quite right. I understand that difficulty. But not everybody has the choice of a home country. If you are an enterprise or a citizen in a country, you're stuck with that system. So again, the debate is not just around multinationals. And I think it's very important that we don't get captured too much by the chase of litigation that may accompany a multinational, and think about the situation where the vast majority of my members come from. They are national enterprises in a national economy dealing with national actors with a failure of the rule of law. They've got nowhere else to go. So I understand timing takes a while, but we've got to keep the focus on that, in my view. Thank you.
Thank you, Brent. Simon?
Thank you very much. A few remarks about building capacity in those countries who need that. I'm very in favor of that. I spoke in my first round about the criminal law procedure in the Netherlands, but we have also some civil law experience as well. And it sounds, and it is a little bit artificial if you see that some farmers from Nigeria are trying to make a statement in the Netherlands which would be affected in Nigeria. That doesn't feel comfortable, not for the farmers themselves, and not for the local authorities in the courts. So I'm very strong in favor of building capacity in those countries as well. And you can train the judicial authorities over there. You can train the lawyers. You can train the prosecutors and the judges. It's very important. Thank you very much.
Thank you, Sam. Richard.
Yes, to building capacity locally. I've been involved for 11 years now in a case which we've been running with the Legal Resources Centre in South Africa for South African gold miners, and during the course of that, 1/3 of them have died. It's taken 11 years. As far as suing in multinational home states, suing parent companies go, I never suggested that that should just be done for the sake of it. What I made clear was that in all these cases there is evidence of a link between the conduct of the parent company and the harm that occurred on the ground. So there's every justification for suing the parent company in those cases, and quite often you find that a business is controlled and orchestrated from the home base. So nothing unusual about that, and an important form of deterrent, I would say, to hold a multinational parent company to account legally in its home base, and for people who need compensation. And it's not right to say that people don't need compensation. People who need compensation to be given an effective compensation remedy which constitutes an effective deterrent as well.
Thank you, Richard. We'll go then to Elida, Cristina.
Gracias.
Thank you. Respecting the rule of law means having laws and means that people are on an equal footing. But this is something that doesn't exist in some countries. In Guatemala, the law on mining doesn't regulate the water issue, for example. The companies can simply decide how much water they use. And then there is the question of there are very many franchises and licenses granted, and there is no prior informed consent. So the rule of law is a questionable point. There are barriers in the way of access to justice for Indigenous peoples. We're going to continue this fight. I think we must pay tribute to the efforts being made in Venezuela to try and put in place policies to ensure that there is access to justice and to make sure there's reparation for damages sustained. Thank you.
Thank you. Thank you very much. Now, I should say two little things. First of all, there has been a lot of unhappiness about country visits undertaken by special procedure mandate holders. And I'd like to assure you that there is a Human Rights Council Code of Conduct for the activities of special procedure mandate holders. And I hope that you're aware of these and that you could actually reference your communications about, and I think particularly Guatemala, in this respect. But I should also say that I do understand your concerns, but also that we would prefer a focus on the work of the working group on business and human rights. We are not so self-centered, but we thought we'd focus the attention on this, and that any further communication on special procedures should be sent directly to the particular special procedure mandate concerned so they can actually address it. I don't think the reference to the other special procedure mandates who are not in the room here. So in many ways, perhaps we want to address that. I also came here to be a moderator and find that 2.5 questions addressed to the working group from Joanna and Surya, and then endorsed by one of our commentators here, so I thought I should say a word or two. We are very keen to implement all 3 pillars of the guiding principles, and we're very keen, if we can, to implement them in an integrated way. But where it's not so possible, we will try and isolate a particular pillar and implement it. Now, what it's been proposed is for us to isolate one particular pillar, in this case, access to remedy, which is quite important. But we would prefer to integrate it. And for us, one way of doing it, particularly on access to judicial remedy, is to focus on state implementation, because through the implementation of states' national action plans, we hope to be able to strengthen access to judicial remedy. That's one way. Now, I'm sure that we will be able to have other communications on specific issues relating to states' responses to egregious violations. Perhaps we may even open up discussions on extraterritorial jurisdiction and so on and so forth. But these are all the sort of things that we need to gather evidence, as I said in my initial presentation. So to assure you, We have not overlooked or ignored access to remedy. It is, for us, the key or one of the keys to effective implementation, and we will take it seriously. And we will welcome any suggestions from Connectors, from Suraya, or from Amnesty on ways in which they think we could approach the subject. Now, on behalf of the working group and on behalf of the Human Rights Council, I'd like to say thank you to our panelists and our commentators for very, very thoughtful and insightful presentations. Ladies and gentlemen, our panel.
Thank you very much. Thank you.